Hey folks, we're back. Today we're going to talk about who has the actual right of disposition. So we've seen in some previous lecture that we have rights associated with disposition, but now who are the people that get to exercise those rights? So let's take a look. In general, now we've established the power of the individual who has disposition rights. We need to address who's given the privilege. This is becoming more and more important as we deal with extended families, divorcees, people who are separated, people with complicated familial relationships, polyamory. We have multiple partners in the same relationship. So you should not undertake the duty of determining who has the right, but you should know the law well enough to advise people what is going on, so you can reduce the liability of the funeral home that you work for by following instructions by the authorized person. If there is a dispute as to who's in charge, state what the law is. If they have questions regarding that, they should contact attorneys, and away you goes. One of the most important developments in recent years is the widespread adoption of right of disposition laws, probably as a result of cremation, which kind of changed the game for everybody. So an effective statute has the following parts: a mechanism for an individual to control his or her disposition at the time of death, refer to that as the mechanism. A detailed priority list specifying who holds the right of disposition. For the sake of clarity, we'll refer to that as the hierarchy. A list of events and situations under which the right of disposition can be taken away, and protections and immunities for funeral homes and other death care providers who act in good faith. So let's look at the mechanism. All states but Michigan give this right because it's just omitted in the law, and 2 other states do not have disposition statutes, so the common law prevails. What this allows you to do is create your pre-need and have it binding on your heirs, successors, next of kin. It allows the following: directions placed in a will or a pre-need contract or some other written instrument that is properly witnessed and notarized, check your individual states, will be the one that people will follow in regards to your disposition. Some states even recognize oral instructions. Some states even have a legally appointed person mechanism who can supersede the next of kin, and Florida is one of them. The legally appointed person on the appropriate military form supersedes blood next of kin even. And every state is different. Now, one thing about Florida's laws, and I say this not just because I am a Florida funeral director and have practiced in the state of Florida exclusively, but because we have such a high death rate and we deal with such a large amount of people that are transient, people who come to us from Canada, from throughout the United States to retire, our death laws are probably the most comprehensive within the United States. And a lot of states look to Florida to throw elections, to see what their death laws are like, and then actually have been basing a lot of their own individual laws off of the Florida statutes. So while the statute may list the priority or the common law hierarchy for the states that do not have a hierarchy statute, okay, losing or forfeiture of that right is an important part of a disposition statute. So why do we need these sort of things? Well, missing relatives. This is one of the most important features of the statute. If a relative cannot be located within a reasonable time frame, the missing person loses the right. The funeral home is permitted to continue in the authority of another person. 40% of all statutes have this provision, and especially if you have family that is extended throughout the U.S. that are not in contact with each other, or even family that lives abroad. So as a case in point, I had a client who passed away, and her next of kin was her brother-in-law. Her husband predeceased her, her son predeceased her. She had no other living relatives, no grandchildren, anything. But she had a brother in England. So under the common law hierarchy, under the Florida hierarchy, the brother would be in charge. And getting a hold of the brother was in and itself a chore. When the brother did respawn, it kind of gunked up the works and all sorts of other fun. But if the brother could not be located within a reasonable time frame, 2 weeks, 3 weeks, no response, can't get a hold of someone, the statute would authorize whoever is stepping forward to go ahead and proceed with items, and thus indemnifying the funeral director, the funeral home especially, and potentially even the person handling the arrangements. And this is a common one. This is a very common issue in today's hotly contested funeral world, especially with cremation. Majority control. Two or more individuals may hold equal control. So a lot of the statutes, the Florida statute especially, will say that any person in a slot in the hierarchy, so in this case, children, okay? If you have a parent that passes away, the spouse is predeceased, and they have 5 children, all 5 children have the right to disposition under the hierarchy. That's the problem. So the statute should give you some idea and some manner of figuring out what to do when you have this issue. Some statutes, unfortunately, are very silent about this. The way the Florida statute addresses it is as long as no one objects, any one person can authorize. In professional practice, okay, a majority. A majority is probably best for you, no matter where you are. A majority of individuals in the appropriate class will basically give you some immunity, but realistically what you want from a best practices point of view is everyone in the class. If there are 5 children, you want 5 signatures on your cremation authorization. You certainly want 5 signatures on your contract. That way you can go after all of them for payment of the bill. Realistically, if there is a problem, don't get involved. Refer the parties to their separate corners, their attorneys or each other. They need to come together as a family. And then when they have made their consent and agreement, make sure you get it all in writing. And if it's a cremation arrangement, the best way to get that in writing is to have all 5 signatures on the form. What happens when people just want to just upset you? You know, go out of their way just to screw the works. Well, a waiver of uncooperative relatives fixes that. Some people do things just to make your life miserable, and some states allow the funeral home to proceed with another individual after 48 to 72 hours. If the individual with the right doesn't utilize it or cooperates with the funeral home, and I am telling you, this is one you better document, perform due diligence, as you almost inevitably are going to get sued by someone looking for a payout. So another practical example of this. This falls into the category of separated but married. If you have a person who's separated from their spouse, has been separated for, well over a decade, hasn't seen them, any contact with them. The problem is the spouse is still in charge under the hierarchy. And whoever they're with is irrelevant. The fact they have kids is irrelevant because under the state laws, some states, that spouse is going to be in charge. And I had that. And the problem is she did exactly what is going on here. Remember, she called me during her lunch hour. She was eating her lunch, smacking her gums, speaking matter-of-factly that she doesn't want this, she doesn't want that. She won't tell me what she wants, so she's literally just doing things to hold it up. So what did I do? I referred both parties to their respective attorneys. When she realized her attorney was going to charge her something along the lines of $250 an hour, very quickly she kind of conceded the fact. Because the alternative in the state of Florida is that a body that is unclaimed and there's no one to take control of, or the surviving relative refuses to give any permission for, ends up going back to the state, and the state processes the individual as if they were an indigent individual. So it kind of backfired on her. Homicide. Going back to our business review, what was the type of statute that prevents a person who has a right of disposition but causes the death and then forfeits their portion of the will? You remember what that is? Called a slayer statute? Exactly. Good. So that only affects the will. A slayer statute only affects the contribution or the devise or the legacy in the will. It does not remove their right to control. You need a separate statute that takes an individual who brings about the death and removes their ability to control the funeral. Florida does have this clause. So the common law hierarchy, the hierarchy you need to know for national board exam purposes, for purposes of general hierarchy questions, and when you get a general hierarchy question, it will inevitably say common law hierarchy or whatever. If you get your state questions, your state statutes, those will be specific under New York law, under Florida law. It will specifically want you to list and determine who the person is that has the right of control. The general common law hierarchy. At the very top is surviving spouse. Surviving spouse. Then biological or adopted children of the deceased. Generally not, okay? A stepchild needs to be adopted. And remember, a stepchild, a half-blood child, something like that, is the issue. You have to ask yourself, who are the parents? And if the parent is not related by blood, consanguinity, but was related by affiliation or marriage, that stepchild does not have control under common law on a person who they are not related to by blood. After children is parents, siblings, and more distant kin. Absent statutory restrictions that we've already discussed, some states weigh the wishes of the deceased, add in powers of attorney or advance directives. Stat will explicitly tell you how these things weigh in. And if something does not tell you what it is, send them to the lawyers, let the lawyers figure it out. That's why they get paid the big bucks. When in doubt, let the court decide. When the man in the black robe sends you a judicial order or comes to a conclusion, it kind of is what it is. Stay out of it. Be neutral. Give good advice to both parties. Okay? And above all else, document every phone call, every discussion, every email, everything. So wishes of the deceased is probably the most important accommodating factor regarding the common law rule, especially in states without a statute. Court is always going to really put its ear to what the person wanted. May be affected by mental capacity at the time of declaration of wishes in a positive or a negative way. May be affected by the time the statement was made in comparison when death occurred. More recent statements closer to the time of death make more sense than statements in the past. I read an article one time, and I can't remember where it was. I wish I could refer to it. But a gentleman, a state politician, a well-loved, well-known, I think it was a governor maybe, or a state representative, someone pretty high up on the food chain, had made statements about where he wanted to be buried. And his wife had passed away. He had remarried, had made statements in the press, had made statements on video. This was well documented. And when he passed away, his children, biological children, wanted him placed where he said. His wife wanted him placed somewhere else. And that comes into play here because the children were able to provide to the court multiple instances over the years where he had mentioned where he wanted to be. I believe it was with his first wife in the cemetery. And that's exactly what happened because he did not dictate that specifically. So it's very important to understand that things can be taken in a court of equity to help push things in the way. Form of precedent is not important. In this case, like I said, it was media. It wasn't a dictation notarized or an attestation in a will. It was him just talking to people. Okay? Courts, however, just like in contracts and anything else, they're going to prefer writing. And courts will balance the wishes against the contrary wishes of the relatives. They're going to seek out estrangement to determine how something should be applied to the circumstances. So, for instance, with our politician, if he was only married to his wife for 6 years, and his adult children, who are in their 40s and have known their dad all that time, and he's repeatedly said over the span of 15 years where he wanted to be. A court is going to say, okay, so yeah, the spouse is important. She has the right of disposition, but realistically, this man has made his wishes very clear, and we are going to listen to that. A special relationship may influence what's going on. So if you have multiple children, the child living under the roof of the individual that passed away is a caregiver or a person who's providing financial support to the individual that passed away. A special intimacy between decedent and the relative may persuade the court to grant that relative the right of disposition. Courts may side with a closer relationship to the deceased, all other things being equal. So if you have a child that was the primary caregiver living under the same roof, was working 2 jobs trying to make ends meet while caring for mom before mom passed, and 4 or 5 other children that were just kind of whatever, chances are that the primary caregiver will have a little bit more of a say with things in the court if it gets that far. States are not consistent on who should prevail in the case of a dispute between a surviving spouse and the contrary wishes of the decedent. And what this is saying is that if you say something in your will, if you make a pre-need, if you do whatever it's going to be, and the spouse themselves challenge it, it's all over the place. Okay? There are certain states like Texas that say that if you have made a pre-need contract with the funeral home is obligated under Texas law to follow that contract to the letter. If they did in any way whatsoever, it's a problem. So if the pre-need called for a direct, immediate cremation with no viewing, no nothing, The family cannot say, well, can we have a viewing and a mass and then have the body cremated? Under Texas law, they would have to cremate the body immediately. Under Florida law, that would be a bit more iffy. Okay, that's a bit more iffy. So even though the person has stated their wishes, that's higher on the hierarchy, a spouse overriding it would certainly be something that is possible under Florida law. Some states recognize the pre-funded arrangement cannot be superseded. We talked about Texas. Some states impose different requirements on how the wish of the decedent must be expressed. So written versus oral, a valid pre-need contract is fairly strong evidence of what goes on. And even things that are ancillary, okay, ancillary things you wouldn't even think of, can tell the court kind of what people might want. So let me rewind back to the individual that passed away. Her brother-in-law was in charge. Her brother lived across the ocean in the United Kingdom. And this brouhaha is going on. And this stretched over for 3 months. I mean, this was not a quick process because I had to wait for the judge to institute the brother-in-law as the administrator and personal representative and give him the authority to dispose of the remains. And the only reason why the judge gave in to the cremation, the only reason, was because her husband was cremated, her son was cremated, they had bought a niche for urns, a double size, so it could fit 3 urns, and her name was on the urn or on the niche marker. So if you walked up and looked at the niche, it had her husband's name and dates, had her son's name and dates, it had her name and birth year. And the judge inferred because she had done this with her previous relatives, because she had put her name on it, and that was the dispositive decision-making item. Because her name was on it, the judge was confident that that's what she wanted and ordered everyone to proceed with the cremation. Some states permit the appointment of an individual, durable power of attorney, healthcare surrogate, whatever, to make funeral arrangements upon death. So another practical issue, another item of extreme importance for you, is most powers of attorney, especially by trained attorneys even, they will put in the payment clause, make the individual responsible for paying the funeral bill. It is important to understand that the right of disposition, we haven't seen anything about payment here. It's completely separate. So you have to understand, get it in your heads, that the right to pay the bill and the right to control disposition are separate. If the power of attorney does not explicitly give them the right to control disposition, the power to control payment is irrelevant. That just gives them the power to pay the bill, and whoever is in the hierarchy controls. Make sure that when you are working with clientele on a pre-need basis, and they say, oh, here's my power of attorney, just go through it. Just go through it and look it over and look for that clause. And if you see just a clause that says, I give my attorney, in fact, the ability to pay for my funeral and all financial obligations associated with the disposition of my body, disposal of my remains, that is not enough. It needs to be something more, and your state statutes may not permit that. So they need to have a very frank discussion with their attorney about that. Normally, the way a power of attorney works, we've seen that in our business law review, is you become an attorney in fact. Remember the springing power. Person becomes incapacitated, you assume their duties. The person has to be alive. You can't represent a dead body. Dead body doesn't make its own decisions. So normally a power of attorney exhausts when the person expires, which is why we refer to some of these as a durable power of attorney. It allows the person to act as the individual after their expiration. Some states allow it to continue. You need to make sure an attorney will know this, will know whether or not they can do things. And why this is important is because an attorney, in fact, isn't an administrator. Okay? It isn't an executor. It isn't a third party. An attorney, in fact, literally is that person. So John Smith fills out a durable power of attorney. In his durable power of attorney, we'll say the state permits this under statute. He directs his best friend, Brian, okay, to handle his disposition, gives him the primary right of disposition, as well as the right to pay his funeral expenses. And he tells, in the instrument and the power of attorney, which fund to use. There's $50,000 in there, and unless you're being really creative, $50,000 will cover most funerals I can imagine. And he passes away. When Brian acts, Brian is acting as John. He is at the top of the hierarchy because that's what a power of attorney does. Some states, they don't care what it is. A power of attorney, go to bottom. The paramount right belongs to the next of kin, which is why wherever you practice, know your laws about hierarchy cold. This is certainly conversations you will have in your professional practice. No doubt in my mind. So protection for us. There are three primary protections that funeral homes want to include in a right of disposition statute: a right to rely, to recover costs, and comprehensive immunity. So the right to rely. It grants the funeral home the ability to rely upon representations of family members. Relieves us from the duty to have to independently investigate every damn thing they say. Think about the death certificate in your state. How many portions of that death certificate have to be filled out? Think about maybe a infant death certificate. For instance, the state of Florida, we have a death certificate for adults, people who lived, and if a child is stillborn, we have to fill out a fetal death certificate, which is legal size paper, 2 sides. Granted, most of that is doctor fill out, but there's a substantial portion that is family related. With the right to rely, we do not have to independently research everything they tell us. We can take it with a grain of truth. We're indemnified. We are immune because we don't need to research the veracity of what they're saying. However, always do your due diligence, ask clarifications, notate discrepancies and how they were resolved, and let your owner manager know anything out of the ordinary. Biggest item that I can tell you is always ask for a driver's license. Always. You don't care if they could drive, they had a Class A CDL. Granny was a big rig driver, which is pretty badass if you think about it. What you care about is the name on it. I have found so many cases where someone tells me they are married, but the last name is different. And then when I say, well, her driver's license says Smith, and you're telling me her last name is Michaels. Oh, well, she's been living with her husband, who's now in a care facility for well over 15 years. They just assumed each other's name. That's an issue, okay? That's an issue because that affects her marital status, which would probably be widowed if she was predeceased, okay? It affects how you're going to list her on a death certificate because if she's been using Michaels and a lot of information, even maybe insurance policies have her assumed last name on there, you might have to do a known alias on the death certificate to confirm identity. And all that is due diligence. If you fail to do it, you may be found negligent and you're opened up to a lawsuit. And trust me, we will discuss this when we talk about funeral home negligence. Your book cites Mack versus Brown, in which a body was cremated under the authorization of the wife. Turns out the deceased never got a divorce. So that first wife never existed. The second wife had no legal status. And if the first wife wanted to, which is exactly what happened, she sued. And if she sues the funeral home without an immunity clause, without you asking, so you are legally married to your husband? Yes, you're done. You have the right to rely. Her name matches. You might even be able to produce a certificate. From there on in, it gets hashed out in the court, and she might be able to do a civil suit against the second wife. Maybe, okay? But certainly, they cannot expect a funeral home to go hunting down a wife they may not even know exists because it simply wasn't said. Well, when families decide to go ahead and put on their own Jerry Springer episode, okay, usually involves delays. Usually can't get cremation authorization signed, usually can't determine what cemetery to put the body in, etc. Well, relative portions of a statute should allow funeral homes the ability to recover storage and refrigeration fees, as well as even requiring embalming for long-term storage as a result of such delays. Remember, this is a delay caused by them, not by you. That is the important factor. So, likely fact pattern. Person passes away, comes to funeral home. You make arrangements. In New York, I understand it to be that a doctor has to sign a death certificate, and once you have a death certificate, you can get approval to dispose of the body. Here in Florida, you have to get a doctor to sign a death certificate and then notify the medical examiner so they can review the cause of death and issue an authorization number. Under Florida law, there's a mandatory 48-hour waiting period. Even if you get all of this done within the matter of 2 hours, which I have back in the old days when you could, that you still have to wait 2 days to cremate in case something changes. Under New York, my understanding is as soon as you get that death certificate, you send it to the ME or the coroner, and they give you a cremation number, an authority date. You can run it straight down and get the cremation done, and it's over with. Well, what happens if you can't get that cremation authorization signed by the family? And you have everything else done, and you're simply waiting on them. You can start charging for it. Yeah, you can start charging for it. And use some discretion with that, okay? Because remember, they're going through a hard time, so you might want to give them, a couple of weeks, etc. But nothing says that you have to store things indefinitely. So remember back to the brother-in-law, brother in England, 3-month delay. One of the very strong leverage tools that I had was the fact that on my side of the pond, I had all my paperwork done. The brother-in-law was not causing the delay. So why would I charge him? The other gentleman was causing the delay. So when I showed him the bill for $3,500 and asked for his signature, I'm not going to sign that. You're the one causing the problem. I promise you, if it gets to court, this will be addressed. And if and when you lose, you will be responsible. It is what it is. Some states allow the funeral home to recover those fees. They have to initiate a lawsuit against the family to allow disposition. If I have to compel, away we go. Maybe a better route would be to turn the body over to the state for disposition. Most people, when they see that a person is going to go the route of an indigent disposition, cremation, and then discard it in a pauper's grave or potter's field, they generally start to pony up. Immunity grants us broad immunity for our actions when acting in good faith from criminal, civil, or disciplinary claims. This means you're going to be sued. Okay, understand, the lawyer's going to make some money. But it means you have an automatic defense. You can raise it immediately. Ask for, summary judgment. I'm done. They're trying to do this. We did everything right. We had no idea the wife existed. Your Honor, there's no case. State statute permits us this. Boom. It's over. Just like that. Some states require the funeral home have the family present the immunity requirements in writing, and it's not a bad idea to add these immunity requirements somewhere on your contract, your statement of goods and services, or your cremation authorization. So let's talk about the Uniform Anatomical Gift Act, bodily donation. This has been instituted in all 50 states in some way, shape, or form. Any individual, majority age, sound mind, okay, may donate all or part of their body upon death. The gift is effective upon death without waiting for probate. Even if the will is declared invalid, if the donation was made in good faith, the donation itself is valid, okay? Donations can be made by documents other than wills. Most of them must be signed by the individual who is doing the donation, so the person who is going to die, in the presence of witnesses, 2 witnesses. We see a lot of the same formalities of a will here. Like I said, during the business law review portion of this course, the law doesn't like to make new things. If something works, they're going to repurpose it. So the same type of formalities for a will work here. Person of sound mind, 2 people to witness the intent. Boom. Many states have their own forms. They do. Many states have their own individual forms and requirements. Surviving spouse, as well as next of kin, may also authorize donation. When we first started studying out of the Mortuary Law book, when you look at, I think it was Chapter 2, Modes of Disposition, remember, Donation to science. The Anatomical Gift Act is a donation to science. That is a mode of disposition. If they have the right to control disposition, this is one of the things they can choose. So order of consent, this should look familiar. It follows the common law hierarchy. Spouse at top, adult children, either parent, adult sibling, guardian at time of death. That one's new, right? We didn't see that with the common law hierarchy. And the person authorized to do so. So let's think about this for a second. Why do you think there's a guardian at time of death here but not under the common law? Let that percolate for about 2 or 3 seconds. Why do we see a guardian at time of death under the Anatomical Gift Act, but we never saw that at common law? Probably, because when you died under the English common law, I mean, we're talking like, feudal area here. The guardian was your spouse or your children or immediately available, or even the lord of the land upon who you worked. You had someone there. Now, in our day and age, especially since the the Uniform Anatomical Gift Act was created, we have an entirely different society. And sometimes a guardian at time of death is who we have and no one else. So specifically, this is something that is modern. The gift can be all or part of a body. If there's no contrary indications by the decedent or someone in the same class as the authorizer or in a higher priority class, all that means is that as long as there's no one higher that says no, everything's going to happen the way it's supposed to. If there's any notice of dissent, the donee cannot accept the gift. The gift can be made to any donee prescribed by the Act, and they must use it for proper research or therapy. No black market, back alley dealing of body parts. That's the takeaway here. Many of the states supersede the Uniform Gift Act with their own statutory, statewide gift act. Many of them parrot this and have much more stringent rules. When the gift is the entire body, the surviving spouse or next of kin may authorize embalming and funeralization subject to the terms of the Act, which generally means if you're doing the donation to science, we don't break out the trocar and do cavity embalming, arterial embalming only in most of the states and in most of the cases. In the remaining couple of states, I think of one state that wants no embalming. Once the person dies, they go right to the medical facility, and they are embalmed by the anatomical board, whoever receives the remains. When the gift is part of the body, the remainder can be delivered to the next of kin for disposition. So if you did a long bone donation or a leg donation, they just take the legs away. The rest can be used for funeralization purposes. Any person acting in good faith to this act will not be liable for damages in a civil action or subject to prosecution. Again, an immunity clause. If you've done everything right, you shouldn't be held liable for the misdeeds of another. Your book notes there is no question regarding the supremacy of a gift made under the Uniform Gift Act or the Uniform Anatomical Gift Act. The donation takes precedence over any contrary wishes of the survivors, but be very much aware that state laws may put restrictions on this. Under the Federal Uniform Gift Act, the decision to donate is supreme, but under a state law, this may not be the case, like here in Florida, if anyone contests the donation. If anyone says, I really don't think I want to do that, it's one of the children and there's a surviving spouse. Here in Florida, the anatomical board shoots it down immediately and will not accept the gift whatsoever, even if there is someone higher on the hierarchy. They don't want to deal with the liability or litigation. So with all these conflicts that go on, all these problems, what happens when the family decides to proverbially lose their minds and start this world of drama? Okay? peopleofwalmart.com. Well, hold the body until the proper person authorizes its disposition. Do not question or influence the decision at all. Point the parties to the separate corners, let the attorneys wrangle it out, and take it to court if they need to. You just guarantee that the body will not be disposed of. Advise all concerned the funeral home will not undertake any disposition until the parties have come to a settlement or until a court has issued final instructions, and always get consents in writing. If a lawyer sends you a consent decree, call the other attorney, due diligence. Make sure the other attorney knows, because they might say, no, we did not agree. I need to give this guy a call. Don't do anything. So as a professional practice point, kind of a diffuser, kind of gets things done, makes you the hero. Remember, disposition is one part of funeralization. That's important. The act of disposing of the body is separate from the rituals that we use for our funerals in a lot of situations. So for instance, if there is someone that is contesting a burial, they do not want the body buried, ask yourself, look at your statutes. Can I have the visitation? Do they object to the visitation? If that's a no, okay, then go on with the visitation. Do you object to the Mass or to the church service or to the service at the high school? No. Have the service. Do you object to having people go to the cemetery as part of the norm for doing this, but then not burying the body, so that at least we can get the funeral and the social thing out of the way, so this stays a family issue and not in everyone else's drama they can talk about? And if they say, we're okay with that, then you can contact the cemetery and say, hey, they have disposition. All we do is use one of your mausoleum areas with chairs rather than outside, and then we'll dismiss everyone, and we take the body back to the funeral home, and then we hold it until the issue is ironed out. Do not assume that because you cannot have disposition, you cannot have a funeral. You might be able to work through all those things, but simply not be able to dispose of the body. And when you do something like that, you've been a helpful agent on both sides. You're a hero to both sides. And this gives them maybe some tension, because now all that is over with, so that tension reduces, and they can come to an agreement. Folks, thank you for your attention. We'll see you in the next lecture.